Hello, everyone, and welcome to Compassionate Conversations. I'm Tanys Coughlan from My Place Home Care, and I'm joined by my beautiful co-host, Heidi Gagne.
Hello.
And we have an awesome guest today, Nicole Bolick. She is a lawyer with Bell and
Baker.
Yes. Thank you. Sorry. I all of a sudden couldn't remember the other name. So thank you so much for joining us, Nicole.
Oh, it's my pleasure. I'm excited to be here.
Awesome. Maybe you could tell us a little bit about yourself and sort of how your practice is, what you practice in.
Yes. So as you mentioned, I'm a lawyer. I do kind of 50% of my practice is in family law. So that's like separations and adoptions, divorces, those kinds of things. And then the other 50% of my practice is in wills, powers of attorney, and estate planning and estate administration. So I think that's more of the focus of the conversation today, and talking about, I guess, planning for that, for your passing at some point long from now, as well as, and things you can do to ease that work and burden on your family and loved ones at that point too.
Awesome.
Yeah.
So maybe tell us a little bit about what are like 3 points that you would love people to know about that.
Yes. So I think anything to do with passing away is something people don't generally want to talk about, or tend to put that to-do list item on the back burner. It's not something you're looking forward to necessarily discussing, maybe for some, but for most, that's not the case. And it is really to think about it as a gift to your family or your loved ones to take the steps to make sure things are prepared and organized for that time. And that's things like preparing a will and powers of attorney. And powers of attorney, I can get a little bit into it if you'd like to, but they're for during your lifetime, whereas a will is for after you pass away. But those are all things you either will or may need at some point in your life, and having those prepared, even if you prepare them and then never look at them again, at least they're done so that if they're needed or when they're needed, your family members don't have to worry.
Right. And I would imagine with powers of attorney, you should also, you shouldn't forget about them because your situations change.
That's true.
And your power of attorney situations may change too. Like I know a lot of people have their children, or, an aunt or an uncle or something like that. I'm my parents' power of attorney, but situations could change, and my sister who lives in Hawaii could suddenly move closer and make her being a power of attorney a little easier. And then my parents would adjust it and include me. So, you really should you should keep an eye on who your power of attorney is, so that you can change it. Is it easy to change a power of attorney?
Yes. So, and I completely agree with you. In an ideal world, in reviewing them, I usually advise my clients to pick a day of the year that is a memorable day for them, but that isn't a day that they're hosting their entire family, like no Christmas or Thanksgiving, anything like that, but maybe like Labor Day, for example. So a day of the year that you look at your documents and make sure they're still the way you want them to be, or if there's any changes necessary. But I know life is busy, so sometimes it's not something you would remember, but picking a memorable day every year and looking at them, because as you mentioned, life does change, and over the years, if family situations change or relocation, like you were saying. But changing your powers of attorney is very easy to do. The same with your will, as long as you have the mental capacity to do so. And mental capacity varies and fluctuates with different people in different circumstances. But for me as a lawyer, it's making sure you're able to understand what you want in the document and understand what the document is. So some people towards the end of life don't have that capacity anymore, but that's when they actually need the power of attorney. They need someone helping them make decisions. So preparing that document in advance is very helpful for your family members.
Right.
So maybe we can just talk a little bit about what that covers, the power of attorney.
Yeah, of course.
For people that may not know.
Yeah. I look at it kind of like an insurance policy, that it's there and you hope you never need it, but it's important to have. And there's both a medical or personal care is usually what it's called, and a financial or property power of attorney. You can name, it's essentially you're naming a decision maker. So if you can't make your own decisions, who would be making them for you? And often people will name the same for both medical and financial, but it really depends on the person. As long as you're naming someone you trust and someone you know will understand what you would have wanted to do in that situation, and they're over 18 years old, then it can be whoever you'd like. Some people will also name joint powers of attorney, so having more than one person working together, which has advantages because then you have two people keeping each other accountable a little bit, especially from a financial perspective. The downside is if those two people don't agree on everything, it can cause some problems or delays in making decisions because they have to agree.
So how many powers of attorney can you have for one? Like, can you have 3 people?
Yep, you can, in theory, name as many people as you'd like. I usually encourage people to keep the grouping as small as possible just to avoid people disagreeing. But it really depends on the family. And I say family, you don't have to name family members as your powers of attorney. As long as it's someone you trust, then that's the most important part. But often I'll see people naming their children working together, let's say, as an example. But that would, I would give different advice if, let's say, one of your children, as you were saying, lives in Hawaii and the other one lives out in the middle of nowhere and you can never reach them because they don't answer their phone. So it might depend on the family dynamics, I guess we could say.
Yeah, and you might not want to have both of them for both. You might want one for financial and one for personal care kind of thing too.
Yeah, exactly.
Especially if they don't agree, then it gives them.
Yes, and you can name alternate people on these documents too. So some people will name their spouse, let's say, as their decision maker, and then their child as an alternate option. And like you mentioned there, you can name different ones. A lot of clients will come to me and say, oh my gosh, my child would never be able to make this difficult medical decision. She's too emotional. I don't want to put her on there. So it kind of depends on the person. And some people are very good with big decisions and paperwork and some aren't. And when you're someone's financial power of attorney or for property, you might, that person might end up making financial decisions for you, but also managing your money. So paying bills and filing taxes. So more of a paperwork and side of things. And if the person you name is very overwhelmed by that or isn't good at that kind of thing, they might not be the right person for the job.
In our experience that I've noticed is a lot of our clients that have power of attorney, the family member that lives closest is generally the personal care. And then another child who might live further away might take care of the financial because it's a little easier to do the financial over the phone, online, and all this versus in person. And with personal care, you tend to have more hands-on. You need to be like, it's helpful to be at the medical appointments and that sort of thing. So I've noticed that is a trend as well. Or if one sibling is more financial savvy or understands that, you know, like I fear for my parents because I'm for both. But I mean, my sister and I do not have a contentious relationship. And while I may be the power of attorney, I know that my sister and I will have no issues in making those kind of decisions together or anything like that, you know. But yeah, you know, there are some people that you know are better at that kind of organization and everything, which would make sense that you'd kind of want to turn to them. But it is very scary giving that kind of power to somebody.
Definitely.
You know, like I'm nervous. Like I'm bad. I still haven't done it for our family. But my youngest is now 18. So now I kind of like, okay, now I'd put both our children together on both things. Is how I would look at it, because my oldest is like 35 and my youngest is 18. So we got a nice stretch of experience and life experience and everything that might be able to would make me feel a little more confident now. I should do it.
And when you're mentioning too that it's scary to do this, I completely agree. Because you're giving someone the power to make a decision for you. That might be a very big decision, or it might be a small decision, or somewhere in the middle. But I guess for a bit of reassurance or information on it, the medical decisions or the personal care power of attorney only comes into effect if a medical professional says this person cannot or does not have the capacity to make this decision.
Right.
So let's say your family member underwent surgery and you were there as their decision maker just in case something went wrong. Just because you were there in that scenario doesn't mean you are now their decision maker for the rest of their life. You're there as needed. And the financial one, which is the one people are more nervous about, to be honest, in my experience, is you can put restrictions in the document saying it's only valid when X, Y, and Z occur. A common one is saying that it's only in effect or valid when there's also a medical note with it saying this person doesn't have the capacity to manage their finances. So you can put some restrictions in there to give yourself a bit of peace of mind knowing this is only going to be used if you really need it. But again, it's complete personal preference and different situations. Someone who's 25 years old making this document might have very different intentions than someone who's 80 years old making this document. So
right. That's good to know. That's an interesting bit of information that there are caveats that you can put into that document to protect yourself. That's because you hear so many scary stories about people taking advantage of that. And, you know, you do everything you can to not be put in that situation. And you just hope that you've covered everything.
Yep. Yeah, exactly. And that's what I warn every single one of my clients. If they put no restrictions, that in theory, their power of attorney could take the power of attorney and go to the bank and say, empty their accounts. I'm here to manage their finances. And if I worked at the bank, I would hope whoever's there might question them. But in theory, they could do that if it's in your best interest. I use in air quotations. So they shouldn't be doing that. But you, again, hear stories of people taking advantage.
Yeah.
So it's good to know that we need to put a note on there if that's the case, right? That they can't really do it just by, then they wouldn't be able to just go and do that. They would have to have it accompanied.
Yep. There has to be a medical reason that you're you're not deemed fit to make those decisions yourself.
Yeah.
I thought that was standard, to be honest. I honestly thought that was standard as a POA, is that you can't do it unless.
That's what it should be used for. But some people use it out of what I say is convenience more than need. So for example, my grandmother I use as an example, if she had to, she could probably figure out how to pay her bills, but she has no interest in learning how to do that. So we help her with it instead. So that wouldn't necessarily be qualifying for a medical note saying she needs help managing her finances, but she doesn't want to do it, essentially. And the other example I would say where I usually say no restrictions is reasonable is between spouses, if they're naming each other as their power of attorney and if they have joint accounts already. Because if you're joint on an account, you don't need a power of attorney. It's your account too, so you can do as you wish with it. But that's very specific to a spousal situation or a family dynamic where you're already planning on assisting, maybe not as a need, but more as a convenience. Or if an older couple is going down to Florida for the winter and they don't want to worry about their bills while they're gone, that's another example too.
Okay. So out of curiosity, I'm not sure if this is something you can answer, but can you add your power of attorney for property to your bank account so that because I know that there's some horror stories that even though you have everything in line, once the person passes, there's still stoppage, there's still, probate, there's still all these other things that can occur that can stop people from accessing the money in your account to provide the services that you need, like your funeral services or anything else, paying off the remaining. Like we just had a client and say, like, I need my invoice now because I don't want anything to get locked up. My mom is not doing well, and so we kind of take care of that quickly. So it's one less thing that he has to think about when the time comes sooner than later. So like, is that also a good suggestion, or is that just a personal suggestion and personal choice of adding that person?
You can add someone as a power of attorney on your account, which is a little bit different from the bank's perspective as adding them jointly on your account, because they're on there to manage it, not because they own it. So when you're joint on a bank account, you both own that account. When it says, let's say Nicole and then power of attorney for Nicole Heidi, that's what it would say on the account. It would explicitly say power of attorney. And you can do that. Some people do, some people don't. It's preference as to what your intentions are. Like my example with my grandmother, she doesn't want to pay her bills, so she needs someone on there to make sure we can. But the unfortunate thing, and what you're kind of highlighting here with when someone passes away, even if you've taken these precautionary steps, powers of attorney aren't relevant anymore once someone passes away. So even if you're on, let's say your parents or your child is added on your account as a power of attorney, the moment you pass, the bank doesn't care if they were the power of attorney, because now we're looking at the will. So it's helpful during your lifetime if you're looking for your power of attorney to help you. But once you pass away, it's almost like we're starting the next chapter.
So what about if they were on as a joint account then? There's no freezing of the account if the person passes.
There shouldn't be. I say shouldn't because my big thing is those who have the gold make the rules, and that's the golden rule. So the bank can make whichever rules they want to because they have all the gold. So they shouldn't freeze the account. Often they do. And that might just be because of the person you happen to speak to that day, or someone's new, or someone, honestly, the bank will hear someone passed away, panic, we have to freeze the account to make sure no one's touching money where they shouldn't be. So it's not necessarily to make your life difficult, even though that is an effect that happens. It's more to make sure it's protective, exactly, to make sure your money's not going to the wrong person or being accessed by the wrong person.
Makes us honest. It makes it life difficult for us honest folk that wouldn't even consider doing anything like that.
Exactly.
Totally get why all these security measures and everything are in place for all this sort of thing. But man, as an honest person that's just trying to help somebody out, it's frustrating.
It is. 100%.
Okay.
But
so
you mentioned,
sorry,
go ahead.
No, please.
You mentioned adding someone jointly on the account, if that would prevent it too. The only time I would, I guess a little tidbit of advice, because all of this, I guess I should have prefaced at the beginning, is more conversation than specifically legal advice.
Yes.
So anyone who is listening, your situation may be different than what we're talking about. So I don't want to take this and run.
Is generalities.
Exactly. But for when you add someone as a joint account holder on paper, that may look like you want them to have that account after you pass away. So if that's your intention, let's say you add your daughter as a joint account holder because after you pass away, whatever money's left, you want her to have it, great. But if you have 5 children and you wanted them all to have that money, on paper, your daughter who's joint with you doesn't need to give it to them because it now belongs to her. So there's some trickiness, I guess, in there, which would depend on the scenario, whether adding them as a joint account holder is a good idea or just might cause a family feud as a result.
Right. And I bet you that happens a lot. There's,
because people are trying to do the right thing and get themselves organized and make sure that no accounts are frozen, and people it's all with good intention, but it does sometimes result in feuds between the family because someone passing away is difficult emotionally, and then once money's involved, it can just turn very sour very quickly, unfortunately.
I'm sure you hear those horror stories of the family never speaking again after a parent passes or something because of it.
That's what I hope everyone's being haunted by the person who passed away when that happens.
Not what I said. That's not what I said. Ooh. So power of attorney is for when you're alive.
Yes.
And then, like you said, the minute the person passes, it becomes the will. So let's talk about wills.
Yes. So
why a will?
Yeah. So your will is what I said again, a big gift to your family members, because it not only says who you want in charge of administering your estate, but also who receives everything you leave behind. And if you don't have a will, everyone is guessing as to what to do, and it might not be what you would have wanted. But also, if they don't have paperwork to say, even if everyone agrees dad's in charge or my sister's in charge, they don't have any paperwork saying that. And often it ends up being that they need to get a court order saying that they are the executor because there was no will to say that. So a will in one aspect is a big gift to your family members to make sure that your wishes are followed, but also they don't have to go jumping through hoops trying to figure out what to do when they have other things to deal with after you've passed away. Right. But the really big aspect of a will is naming your executor, which is who's in charge. And that one can also have alternate options or joint people working together, like a power of attorney. And then who your beneficiaries are, which is who's getting what, essentially.
Right. And can you, like, in a will, can you, for beneficiaries, can you, like, bring it right down to as detailed as you want to?
Yeah, some people will put, I don't know if you mean from a money perspective or a personal item perspective, or
kind
both.
of in general, like, yeah, both. Yeah. Is there something like you could specifically say that, you know, this spoon that I got in England from this trip with this person, I would like them to have this spoon?
Yep. You could. Wow. You can be as specific as you'd like, or as detailed as you'd like, especially with personal items. Some people will put that in their will. Some people will leave a note at home saying who gets what in the house. You can do that, just the note at home isn't a legal document. So if your family members decide not to follow it, they can't get in legal trouble. Right. Whereas a will has to be followed legally. So if it says the spoon in the dining room from England or whatever it is, then goes to this person, that's what needs to happen.
And what is the fallout if a will isn't followed?
I hate that my answer is it depends, because it depends.
It's situational, yeah.
Yeah, if let's say in this personal item example, or it's something bigger like a big painting or a dining room set or something, and you left it to a specific person. Let's say they didn't want it, and one of the other family members wanted it, and everyone is in agreement that that other family member will get it, then that's likely what will happen, as long as everyone's in agreement. Right. So there's no overarching government body making sure that you're doing what you're supposed to be doing in Ontario. But it's more from a monetary perspective, or the money side of things, where there's more paperwork and filing of documents to track to make sure what happens. So from a personal property perspective, I would say there's a bit of wiggle room as long as everyone's okay with what's going on.
Right. And so then when it comes to finances, how everything is split. So, okay, I have a question then. If you have a property, a decent sized property worth, say, $500,000, but on said property, you have multiple pieces of farming equipment, which can relate to, say, $100,000 in that equipment cost. Is it possible to state in your will that certain pieces of equipment at this value can be kind of included in the monetary value, or so it's just my friend's husband's family recently lost their father, and he had said kind of property with a lot of farm equipment, but there's a lot of contention in the family. And, you know, would you recommend like an estate sale at that point in time, where you kind of sell everything and then it becomes monetary and then divided as per their dad's request? Because if you start trying to put value on items and divide it up like that, it just seems so difficult and very, very contentious, because some people might assume it's valued at higher rate. I'm just curious, like, can you be specific in this needs to be sold off and then the money separated, and then if the person wants to buy it, they can buy it?
You can, and people will do that with their cars, for example.
Okay.
Saying, this person will have my car, but if they don't want it, it can be sold and they'll get the money or something. I would say that in a much more legal terms. But
right. We are good with layman terms.
This is casual conversation.
But often what wills will say when it comes to the money side of things is either that someone gets a specific amount of money or that the residue of the estate is divided. And what residue means is what's left. So when someone passes away, the priority is always to pay bills, pay taxes, pay debts,
right.
pay funeral, all those things first. And then whatever's left is the residue. And in your friend's situation, there's a home and there's expensive equipment on the property. But if it says the residue, so what's left, let's say, is divided in two between my two children, just to give a simple idea. If neither one of those two children want the house or the tractor or things like that, then it would make the most sense to sell it at a fair market value and divide the money. But let's say if one of the siblings wants the tractor or the lawnmower or something like that,
right.
There are actually people in the Ottawa area that I've dealt with before who appraise items, and I would say odd items is what I would categorize it as, or maybe not everyday things, and provide you with an appraisal report or a fair market value. And if people are contentious in a situation and want proof of the value of something, you can hire someone to give you a formal value, because then you essentially purchase it from the estate at that value.
Right. But you can't then put that money. So say you were going to purchase the tractor for $50,000 and in the estate, you're looking at getting $100,000. You can't, you'd have to physically pay the $50,000 and then it would go into the estate and then you'd get a percentage from that 50. Is that how it works?
Some people do it that way, or if you're using the round numbers you're using, I'm entitled to $100,000, but I want this $50,000 tractor. I'll take the tractor and $50,000, and then the rest would go to. So as long as I say everything's in writing, because people may change their mind about things, but if everyone's in agreement that the tractor is worth $50,000, and that's, instead of you getting that cash, you're getting the tractor. Or even on a smaller scale, let's say your deceased relative left a car that was worth $5,000 and then you wanted the car instead of the $5,000, then as long as everything's in writing, it can be done that way. Okay. But when people don't get along, sometimes it's very difficult to do those things.
Yeah. Okay. My other question, because this is kind of relevant in my husband's and my situation. So we need to get a new vehicle.
Okay.
and I said to your dad, I said to my husband, I'm like, well, what if we were to borrow the money from your dad to purchase this vehicle and pay him, pay monthly installments, but then when he passes, because I don't want him to pass at all. Heaven forbid. Love the man. He's wonderful. But if he were to pass while we still had this loan with him, can that loan be automatically deducted from any inheritance, any cash inheritance that my husband would get? Is that possible? Would you need to put that in writing? How would you handle any kind of loan that you've provided for your children?
Yeah, it's a great question, because it is fairly common. And I would recommend that his father acknowledge that loan in his will and what he wants happening after he passes. So whether it's, some people will say the amount owing is deducted from the amount he receives. Some people will say if there's any amount owing when I pass away, it's forgiven. It completely depends on the agreement that you had.
Okay.
And what some people will do as well, kind of in the reverse, I don't know if your husband has siblings or what his father's will says. I'm speculating here. But he might say, I lent my son $20,000. So as a result, I'm giving $20,000 to his siblings, and then they divide the rest at the end. So let's say this is a loan you weren't necessarily paying back. You were just,
Right.
when we get to it, we get to it kind of thing.
Right.
Some people will do that to say, I essentially gifted him money while I was alive, so I'll gift the others money now, and then you can divide the rest between you.
And then they're, okay, that makes a good sense.
Yeah.
That seems like the easiest way to handle if you were going to start loaning your children some money. That whatever's left in the amount owing would be then gifted to the siblings.
Or if it's some people, like if it's a loan, like I said, that they don't necessarily want paid back, it's more of a gift, but I want it to be equal between my children, then that's a way to deal with it in the will.
Okay.
But it's a really good question because it does come up quite often.
I would imagine.
And I mean, like my parents helped us out at many times, where we did have a loan with them because, when I was young, banks are like, yeah, you're a bartender. I don't really trust that you're going to pay me back, but my parents know where I live. So it's all good, but so over the time, like my parents, it's not unusual. And we've lent money to our oldest when she was struggling. So, I mean, it's not unusual that parents will help children out, but I mean, I wish I could not make her pay me back for that loan, but not real. That's not logical because I do need her to pay me back. But so that is good to know. Again, I have not set up my will and I keep telling myself I need to do that, but she does owe us a certain monetary amount. So when I do create that will, I probably should put any outstanding loans or whatever, like would be then the same amount would be then given to our other child kind of thing. So that's good to know.
Yeah. And honestly, the best way with that too is just because often with family loans, there's no formal documents.
No.
So just keeping something somewhere that tracks what has been paid, because let's say in that situation, was it your daughter you said?
Yeah.
Your daughter says, oh, I've paid it all back. There's nothing owing, but that's not the truth. So having something somewhere, writing it out.
What happens if that does happen? If they say, oh, no, I borrowed $100,000 from dad. I paid it back a long time ago. And your sister's like, did you though? So what recourse would you have to say, because that's a lot of money. Like what recourse would you have to say, where did you pay him back? I don't see it here.
Yeah, it would be up to the executor, so the person in charge of your estate, to determine it, because they're the ones who have to figure out who gets what based on what your will says. And they should have access, let's say, to your banking records, which would show e-transfers or something like that. It's very difficult if this is being paid back in cash because there's probably no paper trail of it. But it would also be in your daughter's interest in this example to prove what she's paid, because that's what's being deducted from what she's receiving.
Right.
But the worst case scenario is everyone ends up in court trying to prove one version of the story, which is never ideal because it's expensive and emotionally consuming and time consuming.
I was just going to throw in a wrench in that and say, what if the person that owed the money is the executor?
Well, what the executor has, I know it's a good question. The executor has an obligation to the beneficiaries to prove to them why they're getting the amount they're getting. Okay. It's very easy to do that if your will says, I give my son $1,000 because no matter what, he's getting $1,000. But if your will says my children get everything equally, even just as plain as that, your executor has to show what that number is. Because when you pass away, you have X amount of money, but then your taxes are paid and your funeral's paid and maybe an accountant or a lawyer is paid and the number changes. So some families say, I trust you, I don't care, send me the money when it's done. Others want a full formal accounting showing mom had this when she passed away and then I paid all these bills and now this is what's left. So even if the executor is the one with the loan, they have to show why that number got to where it is, which would be proof of the loan being paid or not paid.
Mm-hmm.
Yeah.
Oh, so
I'm all of a sudden glad to
picky.
be an only child.
Yeah.
Yeah.
It can become a big ball of the ball gets like of snow, I guess is the good metaphor. It gets bigger and bigger very quickly.
You know, and sometimes you can see it in the family dynamic early that you're like, oh my gosh, this is gonna be fun when this when this person passes. This is gonna be fun. But then I'm sure there's other people where you're like, this won't be an issue. I know for us, I have one sister, and we're not out to get whatever we can get out of our parents' estate or anything like that. And we're, it's like split right down the middle, like everything split completely. Mm-hmm. And then, because that's how my grandparents set it up on my mom's side, is basically these items. My grandmother was very organized, and she had her daughters come, and they actually went through her house, and she itemized everything to say, this is what you want, this when I pass. Okay, wow. You can have this. And it was, yeah, she's beautiful. If she had Excel spreadsheets when she was younger, it would have been beautiful. So I might be a little bit like her. A little bit. Because I do have a spreadsheet of the payback from my daughter. And when my other daughter borrows money from us, when she goes off to school, I'm sure I'll do the same thing for her, because I'm just like that. But my grandparents were just like, this is what everybody wanted for property stuff. And then everything else is divided just up between the her children. Like the grandchildren didn't get anything, and it was then up to the parents' decision as to how they wanted to disperse their amount. And I was like, you know what, that's a really great way of doing it, especially if you have many grandchildren or only just a few grandchildren, because like my aunt didn't have any kids, but my other aunt had 2, and my mom had 2. So, like it's kind of, here's everything, you guys decide how you want to do it. Yeah, which I thought was was a smart way,
It is, yeah, and it's even as you're mentioning it too, it's so family dependent too, because some people having that kind of organize yourselves mentality does not work, but for some people it does. So it really is family dependent, unfortunately. And then even we're giving lots of examples within the family. You can leave things to charity, to your friends, to your neighbors. Like you can do whatever you want in your will, as long as someone knows where to find your will. That is the most important part, because in Ontario, we don't actually have a will registry system or anything like that. They have that in Quebec, but in Ontario, there's some unofficial ones that you're not required to do. So it's not the most reliable thing. But letting your family members or your executor know where your will is very important.
So there isn't any place you can safely store your will? Like, is there only a hard copy? Is there an electronic copy that, your lawyer would have? Or no, it's strictly in you?
It depends on the lawyer. So for me, I will offer to store your will in our safe here, or you can take it home. And I always keep a copy, like a scanned copy. But when you pass away, you will, or your executor, not you, will need the original one. So then knowing where to look for that is very important. Some people have a safe at home. I've heard of people putting things in their freezer. I don't know how reliable that is. And then lawyers often have a safe at their office you can put them in. But the issue is if your family members don't know where to look, then it can become a big headache trying to find your will. So you don't need to necessarily know or let your family know what your will says if you don't want to, but letting them know where it is important.
That makes sense. Okay, so I wanted to touch on, actually, the owner of the company wanted me to ask you this. He's like, what happens when a business owner passes and doesn't have a will, but has a business? So how do you know, that's estate planning, but this is small business. I don't know if that's under your purview, but Do you know the answer to that?
Somewhat. I'm not an expert in corporate or business law. I will preface with that. But it depends on the type of business, because if you're a sole proprietor, which means you own the business 100%, no one else owns it, it would be different than if you own a business with 15 other people. Often in the articles of incorporation, which is the documents the owner signed to create the company, it would say what happens if one of them passes, if it's owned by multiple people, which is often the others can buy their shares or some version of that. If you're a sole proprietor and you don't have a will, in theory, this belongs to you, so it would fall into your personal will. You can have a corporate will, and I do encourage people who have their own corporation, even if it's just a holding company, or you, I've had a few clients who are medical professionals and they're retired, but their medical business still exists because they're slowly withdrawing money from it. Whatever version of it is, even if it's a very small asset, let's say, or a very big one, having a corporate will to address what happens is helpful. It's not required, but it definitely helps your executor, so who's in charge, know that they're in charge, but also where the value of that business would go or what would happen. So I'm assuming your boss, I don't know, actually. I don't know if they're the only owner or if there are other owners in the company or what the dynamic.
No, he is the only owner.
Okay.
So, but that's interesting. I did not know that corporate wills existed.
Yes. Yeah. So it would be specifically for your corporation, nothing else.
Right.
And it helps separate the two so that they're not all falling into the same pot of money and emotions and family dynamics,
right?
We could say. So that is something I do work on is corporate wills for some clients. But often I would want to see their articles of incorporation too, to make sure their will says the same thing. Because some people will put in their business that if I die, my son gets first priority at my company if he wants to buy it, for example. And if the will says something different, then that will cause problems.
Right. Okay. So there's a corporate will. And okay. And then, but if a business owner dies without the will or a corporate will, and then it just basically does that mean like the business goes into like, what is it, probate or something like that when there isn't?
Yes, if you don't have a will, then there would definitely, I know, like, talk about probate too, and that daunting term we all hear about.
Yeah.
It's scary term. But if you have a personal will, it would likely need to be probated anyway. But the business would be seen as an asset, assuming it has value. So that's kind of like putting the house up for sale. It's putting the business up for sale. And if someone else wants to purchase it, then they can. And that would be dealt with through a corporate lawyer to make sure everything's done properly and at a fair value. I did have a client who passed away with a regular will, but not a corporate will. And that's what ended up happening is her business was for sale for someone to purchase. And luckily it ended up being purchased. So
yeah, what happens if it doesn't get purchased?
Well, it's tricky because it belongs to the estate. So it's essentially the executor would be helping run this business until it's either closed down or sold. And when there's employees and payroll and taxes, it just becomes very challenging very quickly.
If you're gonna get a business, start a business,
have
a corporate will.
Yes.
Or your family or executor is gonna curse you for the rest of their days.
Yes. Right. And on that as well, just a side note that I didn't really mention with powers of attorney. I know I'm throwing a lot of information your way. But the property power of attorney, so the financial one, you're allowed to have more than one of those at the same time. So they're always called a continuing power of attorney for property because you can have one, like generally people have one and it's just manage my things if I'm not able to. But some people have one and for their personal and one for their corporate, saying if I am unable, I'm in a coma, something happens, this person is my power of attorney for my business and this person is my power of attorney for my personal finances. So naming like a business partner or a manager or someone you trust, that kind of thing for the corporate side of things.
That would make sense because, if you have some kind of business that involves finance and you have your power of attorney is your daughter who doesn't know anything about finances but suddenly needs to run a corporation. Oh wait, isn't that a rom-com? I'm pretty sure there's a few rom-coms or something out there with that preface, but it's harder in real life.
Yeah.
Exactly. Yeah.
Okay,
Wow.
so we have touched on probate. What is probate?
Yes. So a lot of people hear about the word probate and it just sounds very daunting and scary to deal with. I promise it's not that difficult if you're organized. That is my advice. So essentially, probate or probating a will is a court order confirming the will, which means confirming who the executor is, or you're getting probate when there is no will, which is a court order confirming who the executor is without having a will. It's not always necessary. It depends on the situation. But the two kind of guarantees for probate is if you own real estate that is not joint with someone else. And by joint, I mean 100% joint owners. Like if I pass away, it's automatically theirs, because some people, let's say, are 1% owners on someone else's house or something like that. That is different. Normally it's your primary home. Let's say you live there with a spouse and one of you passes, it goes to the other spouse. There's no issues there. But if you own a home that's just yours, your will need to be probated, because your executor needs that court order to be able to sell your home. Because essentially the purpose of that court order is to make sure that it's the real will being followed. And it's not, I'm the executor, and a month later, your long distance cousin shows up and says, no, I'm the executor, and this is their actual will. So, yeah. So, and especially something big like a house, you want to make sure that's being dealt with by the right person.
Okay.
Definitely.
And the other reason for probate, which is a bit more vague, unfortunately, is if the bank requires it. And why the bank would require it is to make sure, kind of what we touched on before, that the money's going to the right person. Often, if you have less than $50,000 in your accounts, they won't require probate. But that is a often not guaranteed rule. It depends completely on the bank and the situation. And getting around it a little bit is if you have joint accounts, kind of like a joint property, it would go to the surviving person. But also with investments, if you have named beneficiaries on those, it would automatically go to them. Because really what the bank's trying to make sure is that the money's going where it's supposed to go. So if during your lifetime you designated your spouse as the beneficiary of, let's say, your RRSP, it would go to them when you pass away. Same as a life insurance or your pension, all those things. If you went out of your way and named who it goes to while you were alive, that's who it goes to. But if you have the will and you know where the bank accounts are and you hire a lawyer, it's not a difficult process to get the probate. People do it themselves, but it depends if you're willing to try and do that. I would say it's not the most user-friendly court process, but the documents are available online somewhere if you want to try and do it yourself.
I feel like I wouldn't. I feel like I'd let the professionals do it. I didn't go through my own purchasing and selling of my house. I feel like having an estate lawyer would be the best option.
I'd say it buys peace of mind.
Like how long can probate last? Like, I mean, you hear about the joys of getting a court appearance kind of thing, and it can be months later. Like, how is there a preference to it, or?
Yeah, it depends which courthouse, because you would file the documents with the jurisdiction, is what we call it, so the area where that person lived. So if they lived in Ottawa, let's say, it would go to the Ottawa courthouse. We do have a lot of surrounding areas in Ottawa, like out in Cornwall and Perth. They have their own courthouses too. Generally, the smaller courthouses process documents faster, in my opinion. Don't tell the bigger courthouses. But if someone lived in Toronto, for example, it takes a lot longer in my experience. So in Ottawa, they're fairly quick. They usually have a turnaround time. I know it doesn't sound quick when I say it out loud, but it takes them about 2 months to get back to us. In Toronto, I've heard upwards of 6 months sometimes to get back to us. So it does depend, on the courthouse you're filing with.
So in that case, in that time frame then, so say, it's 2 months, which seems pretty reasonable. It doesn't sound unreasonable for 2 months, except if you can't do anything and you still have to pay the mortgage on this house, you still have property taxes on this house, and you don't have the money accessed from the deceased person's account. So does it then all fall on the executor? Like, how does that then happen while you wait those reasonably 2 months? But a lot of expenses can come up during that time.
There's two options to make sure that doesn't fall on the executor. Essentially, the first is before you pass away, and I don't do it now, but I'm sure one day I will, and I probably should, is having your bills on auto pay. Because the bank, although they may freeze your accounts after they pass away, they should not, and your executor can directly say, do not do this. They should not freeze your auto payments for, let's say, hydro and gas and mortgage, things like that. Those can keep going through. If auto payments are not an option, I'm sure the bank wants to be paid, so I'm sure they'll take the mortgage. But any other bills, especially older population, might have paper bills coming in the mail. You can physically bring the bill to the deceased person's bank and they will pay the bill from their account. If you pay it and then tell the bank to pay you back, they won't do that. But you can bring the bill that has the person's name on it and ask them to pay for it.
And you'd have to bring the death certificate with you for that.
Yeah, exactly. Yeah.
Which then you also have to wait for. You still have to wait for the death certificate.
Yes. Luckily, I have found funeral homes are pretty good about, they're pretty quick about providing them, but it does feel like a lot of chicken and the egg situation where you need this to do this, but you need that to do it. And it's a lot of push and pull. It's not an easy job necessarily, but the knowing, your family members or your executor knowing where your assets and debts are is something I would put in that same filing cabinet at home that you have a copy of your will and your important information. Just put a little note or spreadsheet, however elaborate you want it to be, of where your assets and debts are, because then they can get the ball rolling a bit faster.
Well, that's good to know. There's a lot of new information. Thank you very much, Nicole, because I did not know about some of these things. So that's great to hear. The advice is, or not advice, the general knowledge, the general information is wonderful to have.
My pleasure.
Do you have any tips for people that are maybe starting to get their wills in order and their POAs? What's some of the first things they should do? And I'm listening because I need to still do it.
Well, I say having something is better than nothing, because I do know sometimes the barrier to getting a will is you don't want to pay a lawyer to do it. I completely understand that. And there are some templates online for things like that. So I would encourage you, if that's the reason you're not getting a will done, to try and have something done instead of nothing. There are parameters you need to follow to make sure your will is legal, even if it's not with a lawyer. Making sure it's dated and you have witnesses and things like that.
Right.
But definitely having something is better than nothing from a power of attorney perspective too. I've dealt with my will was written on a napkin at the kitchen table and it was still a will. So having something's better than nothing. But I would say it's what I often will send people if they're ready to talk about it, they just don't want to do it right now, is we'll book an appointment a few months away and I'll send them a questionnaire to start filling out so that they don't feel rushed, but they are working towards having this done, because you're never going to be in well, at least in my experience, you're never going to say, I really want to do my will today. It's just something you don't really want to do. Yeah.
I don't know. After this conversation, people might.
Yeah, that's true. That's true.
Go grocery shopping, make a will.
Yeah.
That's my to-do list for today.
Yeah. Oh my gosh. But having at least the appointment booked sometimes gives people that push to start working on it. But it's really thinking about the big points of who you want to name as being the person in charge. So that's your powers of attorney and your executor, and who you want as your beneficiaries. Those are the two questions. And I know they're really big questions, but that's really what you have to think about before coming to the meeting. Everything else we can discuss when you're here. But thinking about those, and you don't even have to be certain, just having an idea of what you want, and then sometimes in conversation that may change.
Okay. And what if so I mean, I don't recall my parents asking me if I wanted to be their power of attorney. It just suddenly appeared in front of me, and they were like, we'd like you to be our power of attorney. Can you sign this? And I did that years ago. Like I don't remember when I actually did it, but I have all the paperwork. But I honestly don't remember doing it. So I guess you need to talk to those people prior and ensure that they want to do it. And, don't just throw them the paperwork and say, because you're living here and your sister's far away, you get to do it. Like,
yeah. It's, you don't need to let them know, but I highly encourage it because it's a big surprise. Legally, you don't have to. Like, you can name whoever you want, but you can't force someone to do it. So if, let's say, I named my neighbor to be my power of attorney and I fell ill, they can just say, I don't want to do that. And then we would look at who the alternate person is. It always says, I name this person to be my power of attorney or my executor. And if they're unwilling or unable, then it's the next person. So asking them does help, because if they don't want to do it, they're not going to do it. So I do encourage it. Yeah. Oh, sorry, I spoke over you.
What about if there's nobody else to do it?
So, some people, you can name literally anyone you trust. I will say that, as long as they're over 18. But some people do name a lawyer or a trust corporation, like a bank trust corporation, to be their power of attorney or their executor. That is one that I don't generally encourage, only because it's very expensive. You have to pay this person to do that job. And unless it's your only option that you're comfortable with, I don't normally encourage it, only because it costs a lot of money. So I usually try and help my clients figure out who it would be that they can trust as the backup or the backup person before. And any one of those people can always come to a lawyer or a financial advisor or whoever it is to help them with that job. But at least then they're getting the help they need. It's not that a lawyer's or a trust corporation's doing everything and charging you for it.
Yes.
Right.
Yeah.
Right.
Which probably isn't my best business advice as a lawyer, but I just...
It's an ethical conversation.
Yes. Yeah, I was going to say, but when you're compassionate and ethical, it's important information to share.
Exactly.
Yeah. And people do name lawyers as their executor often. Like I've seen it a lot. It's just, if you have other options, I would encourage the other options.
Yeah, no doubt.
Unless you're like a wealthy bajillionaire and you're like, you know what, I like my lawyer is cool, he can decide everything, or she can decide everything.
So I'm thinking, if you're like a famous celebrity and you have millions and millions of dollars, maybe a lawyer is better to deal with that, but that's not my normal clientele. So
no, you don't have billionaire celebrities? Weird.
Not that I know of.
Somebody's in hiding from LA, they've moved to Canada. You never know. You never know. That's awesome.
Well, I can't believe it's been an hour.
Almost an hour.
Yeah. It flew by, but
it did.
I think it was all good conversation, and I'm hoping it encourages people to take steps while they have the capacity to do so, but also the willingness to do so to help their family members later on.
Yeah. And start having that conversation with your loved ones. Can't say that enough in all our podcasts, is you need to start having conversations with your your family, with your whoever's going to be your power of attorney or your parents. Like I have regular conversations now with my parents, especially since I've started in this company and this industry and learning all this. Like, yeah, okay, we need to have talks about this. As uncomfortable as it is, we need to talk about this. And it's relatively open in our family because we don't want it to happen, but we understand it will happen. So it is important to have
that. One of those things, right?
Yeah.
Yeah.
And it's
exactly.
You know, what's always going to happen? Death and taxes.
There you go. And it is uncomfortable, like you said. It's an uncomfortable conversation, but as long, like, I wouldn't say spring this on your kids, but you can say we're going to have dinner and talk about this, and it's what's happening, so they at least know what's coming.
Yeah, I got my kids in the car for 16 hours on our road trip, so maybe I'll start bringing that up and talking to them now.
They can't go anywhere.
Like, yeah, you guys can spread our $10 between the two of you. There you go.
Oh my god.
Well, we just had a whole bunch of car repairs on both vehicles, so yeah, I'm looking at $10. That's what you got. I love being an adult.
Yeah.
Being an adult is fun.
It is. Thank you so much for joining us today, Nicole. We really appreciate all of your insights, and it's been just a pleasure and an honor to have you. So thank you. And don't forget to come back next time, guys, for Compassionate Chats, and we'll see you all soon. Bye now.
Bye.